So this is January 29th, 2026, and it's a monthly staff meeting for the Parole Board. And first item on our agenda is to approve our agenda. Are there any additions or deletions that we have in order?
I have a few additions, but I wanted to see if anybody else had any first.
Okay. I don't think they do, so it's on to you.
All right. I would like to add a parole violation reconsideration after the early discharge review.
Okay.
All right. I'd like to move the Department of Corrections up after the minutes. They should be on around 9:15, 9:20. They had a change in their legislative schedule, so I thought we might as well have that done.
Yeah.
Added to the general discussion topic, subpoenas, board's ability to issue them.
Good.
And then I had another one that was listed as motions, but I don't have a reason why, but I figured it's not, we could put that in general discussion. I don't think it's a bad thing, just to refresh a little bit. And maybe it'll come to whoever might have brought it up to me why I wrote it down.
Okay.
But just a general refresher doesn't hurt.
No. So I got the addition of a reconsideration at our early discharge after case review there. And then a couple of items, subpoenas and motions to our general discussion. And just on my agenda, I've got the Department of Corrections up after the minutes anyway.
Right, because I sent you an updated one, Dean, yesterday.
That's what I got. Okay.
So
a motion would be in order to approve the amended agenda.
So moved.
And second. Motion's made and seconded to approve the amended agenda. All those in favor signify by saying aye.
Aye.
Okay. Are there any opposed? No. And next up is to review our minutes from our September and October staff meetings. Hoping everyone has had a chance to review them. We start with the September ones and the motion for their approval.
I'll make a motion that we approve the minutes.
Second.
I'll second.
Thank you. Motion's made and seconded to approve the minutes from the September 2025 staff meeting. Are there any corrections or changes to the minutes that anyone has?
I didn't.
Okay. All those in favor of approving them as written signify by saying aye.
Aye.
Any opposed? We are unanimous. And then the October 2025 minutes.
I'll make a motion that we accept the October 2025 minutes.
Second. Thank you. Motion's made and seconded to accept the minutes from October 2025. Are there any corrections or changes to those minutes? All in favor signify by saying aye.
Aye.
Aye. We are unanimous. And we are all set to begin with the Department of Corrections when they get here.
All right. And I thought we were going to be, I have a hard time estimating time. So they're coming in about 9:15, maybe a little bit later. Lori said she was stuck on the interstate behind a snowplow. I don't know if we want to move to the early discharge in the meantime.
I was going to suggest that. Why don't we take a look at the early discharge case for Stephen Bashan?
Mm-hmm.
I didn't have any problems with him at all.
Yeah.
It was a nice hearing that you guys ran too. It was just very positive. And so
I think it was as I recall, he was involved in drug selling, but essentially to pay for his habit. And he's done really well since then, gotten himself back on track and working, and had a very supportive report from his PO.
yeah, the only thing I saw was he wanted to get off the MAT program, but I see he's still on it. Other than that,
Yeah. If no one has any objection, then a motion to put him on the agenda for an early discharge hearing would be in order.
so moved.
Second.
Motion's made by Tom, seconded by Wayne to schedule Stephen Basham for an early discharge hearing. All those in favor signify by saying aye.
All right.
Aye.
Aye. Any opposed? Great. Thank you. Morning, Gary.
He looks confused. Whoops.
He came, he left.
Yeah.
He's still here. I think he's trying to figure out his computer. It's all
I know.
good.
Yeah.
Do we want to take up that policy question that Tom had about early discharges while we,
Well, we're on that
Um,
subject.
yes.
Thanks. So under general discussion, one of the questions was when we, sorry here. No, it
It's
isn't
under
under
the-
general. It's under discharge. I got it. Yeah.
Yep.
Tom, so you raised the question about if there's non-payment of restitution, is that grounds to deny early discharge?
I remember when I first started, it seems like a decade ago, there was a couple cases and he had not made restitution. Everything else was run, and we did not grant parole because he had not done due diligence. And I've seen a couple recently where they have been paying, but they still owed quite a bit, but we still paroled them. And I just a little clarification because
Mm-hmm.
if they're not, so if they don't pay, we don't, I mean, I think know what people think. If they aren't paying at all, what do we do? And if they are paying a little bit, what do we do? And if they're doing
Yeah.
due diligence, that's all.
Yeah. And I think for the most, you're right, Tom, there's different prospects on that. And I think for the most part, if someone is making regular payments on their restitution and they indicate in the interview that they plan to continue, then we consider that matter as being one that's favorable for them. Sam, if someone is not on supervision, does your restitution unit still have ways to go after the restitution?
We can, yeah. So we collect what until it's paid in full or they're deceased. For me, I read the condition as a plan agreed upon with their office and the satisfaction of the probation officer. So that's where I would go with it is, are they in contact? Are they doing what they need to do to fulfill the condition? That's kind of my take on it.
Yeah.
But I know that we granted early discharge to somebody who was making payments and still owed.
Yeah.
I think it could be a case by case basis where,
Yeah.
but did that answer your question?
No,
Yes.
what if somebody's not paying at all?
I mean,
I
we
think that
still-
would definitely, yeah, go ahead, Sam.
So I mean, we can definitely talk about this at a different time too. I don't want to take up the whole morning talking about it, but there are other avenues that the unit can take to try to enforce. But it's hard and there's no teeth. So
I guess my thinking, Tom, is if they're not making payments, that would be a negative.
Yeah, that's what I was looking. That's what I was looking for. Okay.
I would also look at the circumstances of the individual too. If they're not
Right.
making payments, why are they not making payments? Have they been in
Mhm.
contact with the restitution
Right.
unit? Looking at the totality of the whole case,
Yep,
not just whether they're making payments or not.
absolutely.
the
Yeah.
other thing that we can do is we can always push back and ask the unit for more information if we feel we need it.
Mm-hmm.
You know, I know we get the summary, I know it has some of the information, but that's something that we can do too. I know sometimes they come on and observe, so
Right.
if we have those questions or we need something, we can kick back to them and ask them for the more information and what they are doing.
Absolutely. Other thoughts from anyone? Okay, Tom, I think that gives you a sense anyway where we're going with this, but I think too that it's case by case, really.
Oh, absolutely. I just
Yeah.
want to make sure that we're on the same page, especially
Yeah.
when they're not paying and no contact and yeah. Okay.
Absolutely. Yeah, good. Super.
God bless you, Katie.
Thank you.
Good morning, Gary.
Morning, Gary.
Good morning.
Morning, Lori.
So MJ, did you want to introduce this next section for us?
Oh, sure. Good morning, Lori and Gary. I know everybody basically said good morning already. Lori had reached out. We have been meeting fairly regularly around just the partnership between the Department of Corrections and us. As many, I don't know if everyone knows, I may assume at this point, but Lori moved on and is the general counsel for the Department of Corrections. So we have been really collaborating a lot more. And as I've been doing the introduction, Attorney Tim Connors has come on too, and I wanted to reintroduce Tim to those who may not know him, who was briefly our attorney before Lori, who is the chief assistant attorney general at AHS, who is now representing us in the meantime. Please tell me, Tim, if I did not represent that correctly.
Oh, good, MJ. Thank you.
All right. So Lori asked to come before you all to just talk to you about the approach that the Department of Corrections is. They're pivoting their approach with parole violations, and she would just like to let you all know what that approach is, and I'm gonna move it over to Lori to do a much better explanation than I will.
Thanks. You did fine, MJ. You did fine. Good morning, everyone. Good
Morning.
to see you. Good to see you all. I hope everyone's hanging in for what seems to be an aggressively long old winter. Old school winter. I just wanted to, as MJ said, I wanted to touch base and be available for any questions that you might have. The face of the presentation from the Department of Corrections in front of you is going to look a little bit different going forward. And so I wanted to explain what we're doing and the rationale therefore, and again, allow you to ask any questions in the meantime. So as many of you know that have been on the board a while, before COVID, you would go facility to facility, the individual would be there, may or may not have an attorney, may or may not have an attorney general available, and they would plead their case on their violation, and you'd make a determination, and we would move forward. As we get locked down and people are put on computers and computer screens, a number of items shifted over to the department, both in the judicial world and in your world in relation to presentation of information. Add on justice reinvestment and the actual numbers that show you all have a much higher caseload on parole than we do on furlough anymore. And then add the complexities of things like presumptive parole, sentencing changes, earned time, and all the legal changes that have happened in the last several years. What it's turned into from the department's perspective is the burden has been put on the department in front of the parole board to be the prosecutors of the violations. That is not the department's role. And what we are doing to align ourselves now with the violation of probation process that we use in the criminal docket. And as many of you may or may not know, we get conditions, probation conditions from the judiciary. Those are our marching orders on how to help the human being, supervise the human being, and otherwise get the human being prepared to reentry to the community. And if we perceive that there's a violation of those conditions, we submit an information and affidavit to the state's attorney in court. We provide them all the evidence that we have to back up that allegation. And then we wait for the hearing to be set. We show up, we answer any questions, explain what we observed and what we saw. And then that is the end of our presentation. We do not subpoena witnesses. We do not subpoena victims to come in. We do not take any other role than to report to the court what we've observed and and in many occasions, the court asks what the department's position would be in relation to a consequence for a violation if it's found. And that's the department's role. As you might imagine, it's very difficult to supervise individuals. We've been criticized a lot, particularly by the parole board, who overrules our recommendations more frequently than not lately, that what we present for information is what we have for information. We are not bound by the rules of evidence or burden of proof. The parole board is. So what we are doing is aligning those so our staff doesn't have two different processes working side by side. But it's difficult to supervise individuals, go in front of the board, essentially prosecute and fillet that individual for whatever perceived behavior we've seen, and then proceed back into the parole office, probation office, and then talk to these people about sanctions and further supervision. So it has become and the parole officers are not trained lawyers. Statutorily, and Attorney Connors is your legal advice to verify me on this. Statutorily, the department does not have to have an attorney present, is not required to. We have the opportunity. It says may ask the assistant attorney generals or the state's attorneys to be present at those violations. I think historically, intentionally, that was written. If you look at the statutory construction that I'm sure many of you were involved in, was to allow the prosecutors who would be prosecuting the underlying criminal cases to be present at the proceeding. It's now turned into the AAGs becoming the actual prosecutorial attorneys in assisting the Department of Corrections. That's not the intent of the statute. And so we recently advised the Attorney General's office that we no longer want their services specific to that docket. And that's also in part because, and you've heard me say several times over the years, the trial division of AAGs that are embedded with the department maintain a caseload now approaching 450 to 480 cases for the four of them. And they're also down an attorney right now. And then we've had an uptick in risk containment cases, obviously. Again, Mr. Marvel's here in part. I'm guessing to answer questions on that. And so we it's very imperative operationally that we align the processes. So what that will look like is a parole officer doing just that, submitting the information and affidavit. If there's more information requested, MJ and the admin team are very good about asking for that. But if you review the information and there's more information that you want, you let us know and we'll get that over to you for consideration. The officer will be available to explain the narrative, answer any questions. Prisoners' rights has still, they're there for their attorney in the manner that they have. They're also aware that we're shifting this process too. Then the parole officer happy to offer suggested recourse for you and discuss what that would look like from their perspective. Whether or not you adopt that or not, that's entirely your call. It's your docket. And then that's the extent of the department's role. The key here is that you issue the conditions when you grant someone parole. We take those conditions and we supervise them and enforce them. And we will let you know if we see a problem. And it's your determination, that's made by you as to whether or not that was in fact a violation of the conditions that you imposed. The department is not going to be an advocate for anything other than letting you know we think a rule was broken. So again, the alignment with the criminal process is key here. That's really the focus because the staff, it's virtually difficult, almost beyond a day's worth of work to supervise these individuals and help connect them with all the services and resources they're required to be connected to, and then come in and prepare a full legal case to prosecute in front of you. That's just not statutorily correct, and so we need to dial that back. So in a nutshell, that's kind of an overview of what the pivot is. We recognize it's going to be probably awkward and clunky for a little bit of time. We want to work through this process collaboratively with you. That's what MJ and I have been discussing on how we ease this transition in a way that you can work through your docket and do your job as well. So, you know, we understand that we have some officers who are you know, also going to, you know, be awkward in the situation because they've been forced into a very heightened level of scrutiny and prosecutorial work that is going to be difficult to dial back. So I appreciate your patience with us as we work through it too, because the staff, this is a pivot for them obviously as well. So I'm happy to answer any questions or take any thoughts on it, but that in a nutshell is what we're pivoting to at this point. Gary, I don't know if there's anything you wanted to supplement from before anybody asks any questions.
No, just here to help answer any questions if anyone's got any operational ones.
Well, obviously, this is a big change in how we proceed with parole violations. And I understand your message to us, Lori, as far as how you're proceeding with handling these. The concern I have is that it's a process that was developed in part because of your advice a couple of years ago, and now we seem to be pivoting away from that, and that's fine. We can make our own decisions on that, but it appears to me that we're heading back to the same way we used to handle things prior to attorneys being present, where the board was more involved in soliciting information or getting evidence presented to it before it made its decision, which we have pivoted away from, and that's going to be a challenge for us.
I have to be mindful, Dean, that on a public meeting to talk about legal advice that I gave you in the past, I would disagree wholeheartedly that this is a pivot from anything I've been instructing you all. And I would also point you to the SDMF work that MJ has been doing to assist you in making consistent decisions and based on the information that is provided to you. I don't recall a time that I ever advised you that that you wouldn't do your work, that the statutory requirements of the board would somehow, we would walk away from those. But
No, I'm not talking about anything with parole eligibility in the SDMF. No, that's clear. These are just violations, particularly. And we morphed into the process we've been using in part because it was very helpful having parole officers with guidance from attorneys when they were competing with attorneys on the other side. And the board was trying to stay out of the position of asking questions of witnesses and then interviewing them when those questions didn't get answered or asked. And this has been a big help to us over the past couple of years. So this is going to be a big change for us.
I understand that and respect that. I think I would just offer that irrespective of what your perspective is on how we were handling things, the board seems to be making their own determinations based on a different standard or that doesn't match the evidentiary standard, and from my perspective and review of the overrides lately. And so
I disagree with that more strongly.
Well, fair enough, but it seems to me that you want to take that power and control back for your board, and I support that wholeheartedly. I think I've heard you all talk to me several times about kind of everything being out of control with the attorneys in the room and turning it into many criminal trials, which is not what the parole board should be, in my perspective. But I defer to your attorney to give you legal advice at this point. This is nothing more than an operational pivot for the department to align with other well-established criminal procedures in front of the criminal courts. So it's nothing different than what we do there.
Questions from the board?
I have none.
No.
Excellent. All right. Well,
Okay. Thank you.
and MJ, let me know if anything else is needed. I appreciate your time, and you guys take care.
You as
Thanks,
well.
Lori.
I'm happy to stay if there's any other questions or issues related to the department that would be
So,
helpful for me to
Gary,
be here for.
Gary, we have had some questions in the recent past on the whole RSN and now risk containment, and I think MJ is setting up an opportunity for some training at our February meeting to help us with that. But if there's anything you want to add to that, it would be great.
So Gary, just to let you know, I've asked, I've asked Jordan Pasha to come over because I heard that he has done a training. Him and Lori did a training with the state's attorneys, I think it was, or the defense. I can't remember. It was with some attorneys. And I asked him if he'd come over and do that training with the board as well. And he is going to come to our February meeting to do some of that as well. But definitely, if there's anything you want to add or talk about now, feel free.
No, I mean that would, that would make sense. Pasha tracks the cases, particularly the risk containment cases, better than anyone else. It's his position, and I know I was present when he provided a similar rundown for AHS, and I think that was very helpful for them to understand our process and our thinking around it. I don't know if there's specific questions I can answer. Is there anything that's unclear or that's it's something that just doesn't connect with what we're saying or doing or communicating that is coming up during these parole hearings?
Well, Gary, now I know Lori has left, but one of the things that I certainly have questions about as we proceed with parole violations. It seems to be moving back into the format that used to be used when there was a Prisoners' Rights Office attorney with the offender and parole officer and then the board. In a case like this, are you doing any training? There's a lot of new parole officers, obviously, with them on how to proceed with violations, or is it simply going to be a matter of here's what we have for information and you move forward and make your own decisions based on that?
They're not getting additional training. The training they're getting is the standard they're getting on community supervision, on foundations, on how to write legal reports, all the things that we've provided training and directive on. Again, like what Lori was saying, the expectation is that we would be providing the same that we provide for the courts when we write a violation of probation.
Yeah, the difference has always been that when a witness is there and they're presented to the board, the Department of Corrections might ask questions of that witness as well. And so I'm not sure if that's going to happen anymore. If it's not,
that would not be to Lori's point, that it's not our role. We see that as not our role. And the primary problem we were running into, particularly that we brought up in the past with these cases where someone's pending a violation, is where you have serious concerns that we're undermining the criminal complaint, and undermining. And we've had that told to us by victims that they're done after having to already go through the process and then having to go through it again through the court. And it's also revealing directly to the defense attorney how that case is going to be disclosed, how that witness is going to be providing their testimony, and that's created some serious problems for us.
Okay, thank you. Anyone have any questions for Gary at this time?
Gary, when your folks prepare a VOP package, what happens to it?
Do you mean before it's submitted to the board?
No, not parole. Violation of probation. When they prepare that package, what happens with it?
It's reviewed by a supervisor and then sent to the court.
The state's attorney doesn't represent? Oh, so they have a prosecutor for the probation violation.
If the state's attorney decides to take it up, correct.
Okay, and if he decides not to, what happens to that VOP?
That's their prerogative. It's between the court and state's attorney.
But what happens? There's no violation brought, correct? If
the state's attorney doesn't want to bring a violation, then the violation won't go. There's nothing. Okay. There's no further involvement from us from that point.
Okay, so your folks are going to prepare a parole package and submit it to Nobody.
A parole
For
packet, a
prosecution.
parole violation.
No, for prosecution of that violation.
It would
Correct?
be submitted to the parole board to carry out their duty. To carry
But
out
we're
their
not
statutory duty.
prosecutors. We're not
That's correct.
prosecutors. We're the court in this scenario.
You have legal counsel.
So I think
correct?
there's a link that all of a sudden is missing here.
Yeah,
Wait, you have
Hey.
legal counsel,
What?
correct?
Yes, we
Yeah.
do, and I just
Thank you.
asked him to come back for some of these questions. I think some of these questions need to be posed to our legal counsel, not to the DOC.
Okay.
thank you, Tim, for rejoining us.
I just jumped in. I'm not sure what the,
We're just trying to process how we're going to be handling these matters. That's quite different from what we've been experiencing in the past. Does our role then become more of a, for lack of a better way of describing it, prosecutor and judge in this matter?
I wouldn't use the term prosecutor and judge. I mean, we're talking about a board. So I think best way to look at it is information gatherer, fact finder, and neutral third party making decisions based on the information that's in front of you. So I think I wouldn't look at yourselves in a prosecutorial role, because it's really not your role. I mean, right? You're a fact finder, and you're going to be presented the facts by parole and probation as necessary, and if you feel like you need more, I'm certain you can ask, and that's going to be fact dependent. I can't getting access to the information could be the challenging part, but I think they're going to lay out the facts as they understand them, and present what they believe to be the violations, and it's for you to hear the other side, and then to make a determination based off what's presented to you.
The issue, I think, Tim, too, that's going to be a bit more of a challenge is that it's not unusual for the prisoner's office attorneys to request confrontation of the evidence, which then kind of changes the role of the board from one of reviewing the evidence as it's presented. If there are witnesses from the Department of Corrections, we don't ask questions of them other than some clarification issues, but it sounds like now we may be more in the arena of, if a witness is presented or requested confrontation exists, then we would have to subpoena that witness and be in the role of asking questions of that witness to determine the evidence, which we don't do now. Does that sound right?
That does sound right. Yes.
Other questions from anyone? Wayne, are you all set?
No, but I can tell right now this is going nowhere. So we'll have more discussion, I guess, because as I think you stated it accurately, Dean. We have gone back to becoming judge, jury, and executioner. Very frustrating. Very frustrating.
Yeah, it's a big change. Okay.
I'll just throw out there, if there's anything lacking in the violation report or any information that you feel is not coming your way, or if there's any guidance you want to make sure our staff receive because of patterns of anything missing that you think would be easier for you to make your decision, that could be presented as part of that packet, please by all means let us know, and we will do everything we can to ensure that information is provided if possible.
And Gary, your people have done great. I mean, they come in, and I know having the assistance of the attorneys at those hearings has been very helpful for them as well.
I appreciate that, Dean.
Yeah.
I know they try, and they do their best with their limited resources as well.
Okay.
All right.
Thank you,
I'll
everyone.
let you be then. Thank you.
All right. Right.
And
If
Tim,
there's
if you
nothing-
wouldn't mind just sticking around for a few more minutes for executive session, that would be Great.
Yeah. So the next item on our agenda is to move to executive session for personnel issues and legal discussion.
So
I'll entertain a
moved.
motion. Tom
Second.
has moved, seconded by Pat, to include Tim Connors if he wishes to attend. All those in favor signify by saying aye.
Aye.
Thank you.
Give me 1 second and I will open that breakout room.
Okay. Okay, the board is back out of executive session and no action was taken and none needed at this point. So the next item on our agenda is the parole violation reconsideration. MJ?
Yep. And I don't know why my hand is up, but hey, that's perfect.
You were anticipating that.
Yeah, I guess so. So I added this late yesterday afternoon. I had just put it in the folder and I wanted to have the opportunity to kind of explain the circumstances before all of you go try to do a full review of the case. Because I don't know if a full review of the case is absolutely needed. So Lawrence Ritchie was continued on parole in October with added conditions. He also had condition 16 at the time and still does. He, however, has no housing options at all. He cannot come up with any. He has written to us twice. He is now involved Don Siebert, his attorney, asking that his parole be rescinded or revoked so he can, because he's work camp eligible, so he can do work camp and max out. So the question that came at hand, and I've been going back and forth, I've had preliminary discussions with our previous legal counsel about whether or not somebody can relinquish their parole status, and I've had conversations with Attorney Connors about how to go about this too. The statute's pretty clear that the only way after you sign your parole agreement for your parole to end is for it to be revoked. That we cannot rescind, and our manual is pretty clear on it too, that we can't rescind parole after the parole agreement has been signed. Unless it's that parole to detainer where that parole was just for the sole purpose to go serve that detainer. So in this case, because his attorney's written, I think a reconsideration's the best method. I feel like if we grant the reconsideration, he's most likely going to waive the parole violation hearing, have his parole revoked, because he's made it more than clear in his letters, in Don's email, that he would just like to max out and earn his work camp good time.
How much
So
time is left in his sentence?
he's got a couple years left. And he has he's been looking, he definitely, from what he's written, what he said, he's very frustrated and I can see where he's coming from.
Yeah.
Yep.
So I just wanted to give you
Ganesh, on that, MJ, and I'm thinking back to a case of a long time ago, but one where we had, I can't remember his name, Pat, maybe you can when we talk about, we had somebody on a detainer out of state who had threatened a judge and so forth, and we revoked his parole after his sentence was satisfied out of state, and the case was appealed to the courts, and it was found that the board had no authority to revoke his parole because they didn't find he violated any conditions.
Right.
And so it was a mess for a long time, and that's how this form now has developed, where there is a special condition.
the Mason case.
Yeah, the Mason. Yeah.
Yep.
So I'm nervous about revoking parole if we don't have cause to do it.
So this one I think is a little bit different, Dean. He's in state. The board did find violation on his conditions violated of 3 and 16. If we were to so here's where my thought is if we were to reconsider, we would be bringing it back for a new violation hearing. Then it's Mr. Ritchie's choice at that point if he wants to go back before the board or if he wants to waive his violation hearing. we
Which
wouldn't
he
be
would be revoked.
revoking his parole. We would just be granting a reconsideration. It restarts the process again. And then it's put into his court on what. And I think this one's a little bit different, being that he's asking for it.
He's asking for it because he can't get out otherwise.
Which, I mean, is it our ethical and moral responsibility to say you must still stay on parole because?
No, I agree, yeah. And maybe we have we looked at amending the agreement to eliminate 16? And whether
We have not looked at the agreement. I think in this case, I think housing was a significant we can put this on hold. You can do a full review of this. I would just say my recommendation as a director would be to remand this for a new hearing and look at the factors again.
Yeah. Okay. What do others think?
I was on that case. I remember it. It's interesting, MJ's legal mind on this one, because I said, oh, that's an option. If somebody doesn't want to be on parole, there should be a venue. I said, I don't want to be, I'm glad you granted me parole. I really want to be on it. There should be some kind of a venue that you should be able to say, but to the system, work within the system. I think that's not a bad idea.
I mean, they had that option in the very beginning, at their original,
Right.
They can always waive their right to be seen by the board, the board, but once they're on it, it's kind of strange to me to think they don't have the option to revoke it if they don't want to.
Kind of like being in the army.
Dishonorable
Oh, well, that's
discharge.
true.
That was actually-
Once you're in, you can't get out until you're discharged, one way or another.
That's a good
And
point.
when I had submitted some statutory changes, that was I believe one of those, it hadn't gotten any. It got dropped off in some of it, but that was one of my suggestions, was to put some clause in there that. I mean, I don't know.
It was very rare.
I would think it would be a hard decision for a parolee to say, I'd rather
Absolutely.
stay incarcerated than go
Exactly.
out into the community.
Right.
Yeah.
I mean, he must
But-
truly be without any housing options at all. I mean, there
Well,
must
it
be
would be
nothing.
approved. I don't know if he's got any others that corrections
It
wouldn't
doesn't
necessarily approve.
If you
Yeah.
look at his letters, it doesn't sound like he has any options.
When he maxes out, that's still going to be there, but it won't be.
Right. And the other factor in this case too is if his parole is eventually revoked, it re-kicks in, he will then come back before the board for his annual reviews and so forth. So it's not like he can't, we're saying you're revoked, you can never come back before the board again as well.
Sure.
I just want to throw that out there too. It doesn't mean that it's, so basically
Done
this
deal forever.
is a decision around reconsideration. If the board is willing to, based on this new information, I know it's a little bit after the 30 days because he's been trying for the last 60 to 90 days to try to find housing. Actually, it's about at 120 days now. If you are willing to reconsider the hearing.
Anyone care to weigh in on it?
For the sake of discussion, I'll make a
Strange
motion.
way to
I'll
do
make a
things.
motion that we reconsider the hearing for the sake of discussion.
Second,
Okay. So the motion is made and seconded to reconsider the hearing for Lawrence Ritchie. Any other discussion? It's one of those things where the earn time thing comes back again to be a problem, and it just,
And the fact he's still in jail, yet he can't earn time. That's
not
part
getting it,
that's
and he's on parole and he can't get out because he can't have a
get out.
residence.
Kind of like a debtor's prison.
You
Well,
know?
and in
Yeah,
this
but-
case, it's not just earn time, because this is camp earn time. So it's not the new earn time law that's
Right.
causing the problem. Camp
Yeah.
earn time has always been in effect. I think
Okay,
this is
yeah.
more of a case of when they're held pending parole release, they're not a sentenced individual they're
Right.
held on a parole detainer still. And that's the status that is triggering why they can't earn.
Do we know from his PO if there have been residences for them to look at even?
I don't have any of that information. It's nobody had
could-
piped up in any of that conversation. So I think if we wanted to schedule something to have a discussion into more of that, I think that may be, I mean, we could even expedite it and put it on for the 4th because we've got plenty of room on the 4th.
Yeah, I don't want to delay it any longer than necessary and have that discussion at that time. And
Sure.
So
your
if Senate
sense, though, Jay, is
237
he's going to
passes,
waive that hearing if we schedule it, right?
I don't know. I'm playing.
Yeah.
I'm
Definitely.
kind of looking at my crystal ball, just going. My professional judgment is telling me most likely,
Yeah.
but I don't know.
Okay.
But if we set it, at least
And he's working
if you
with-
decide to set it, then we're setting in that our reconsideration process.
Would you be responding back to him and to Don Siebert?
Yes.
Okay. And so if we agree with the motion and it passes, could your correspondence include just a note that the board is also interested in what the issues are around the residents?
Yep.
And then they may decide to at least show up before they waive the hearing and we can have that discussion.
Yeah.
Anything else on that? All in favor of the motion, signify by saying aye.
Aye.
Any opposed? Interesting. General discussion. Wayne, you had something on compressed air pellet guns?
I found my old notes, Wayne. This was the subpoena
guess
case.
so.
If I need to,
oh,
I remember.
mackerel.
I can-
thought that
I
was-
can-
That last night,
that
I'm
case I
going,
have like grilled in my head. If you need me to give you like a brief overview, I can refresh everybody's memory.
Tepeda was the guy in Burlington?
This was the guy in Burlington who left his encampment on his
And
bicycle,
the
Oh,
and his
yeah.
The guy in the
girlfriend
paint
stole his
shop?
pellet gun.
Yes.
guy in the paint shop saw the shooting going on, called the cops. Yeah,
And he
Um,
on his bicycle knew that there was nothing, that it wasn't loaded, so he waved his hands and said, "Go ahead, shoot me." And she did, and nothing came out.
yeah.
Oh, wow. Okay, then.
I left out the part that he was in his underwear on his bicycle on
Yes.
the public road. It was an entertaining case that went into. We had other stuff come out of Sapita because it went to
There
court
has to be
too.
a lot of, there had to have been some mental health stuff going on there.
A little.
I can't remember which way I was going with this, MJ.
Well, I think you were saying,
In
do we
his
need to
underwear.
consider deadly weapons? Because is that
Huh?
I think you did some research around are those air pellet guns, are they considered a deadly weapon or a weapon? I think that's where you were going with it, Wayne, but I
Yeah,
can't.
I can remember back when I read
100%.
it, I did look at, I looked at the definition. Yeah, okay, he charged this as possession of a firearm. That's what provoked me to do this. And the night before, I read didn't he, MJ? Can you just confirm that?
Yeah, I'm gonna pull up her case. Give me 1 second.
But I
Working
think
on
that's
it.
what provoked me to look up, and
I
a
think so
pellet
too.
gun does not meet a firearm. However, if you read this whole scenario and the cops responding and the paint store owner watching this, deadly force would have certainly been applied in this case.
Mhm.
But I know it's a slippery slope if we add deadly weapons, because now we got golf clubs, baseball bats,
We gotta
and
define it.
everything else under the sun that corrections will go in our house and say, oh, there's deadly weapons in there. They can't go there.
Yeah, we'd have to define it for sure.
I think the simplest thing is if we wanted to go down that road would say in our definition of you shall not possess a firearm or ammunition, that a firearm includes in our definition a compressed air pellet gun.
Yes, you're
That would
correct.
work.
You're correct. The board did take no action on you shall not purchase, possess, or handle firearms and or ammunition because that was
Yeah,
what was raised.
yeah, that was, because I said it doesn't meet the definition,
Right.
Right.
so I can't fire.
It's not a federal definition, but boards and states have included it in some of their restrictions specifically.
Well, it's like a crossbow has the same hitting power now as a rifle. So, but the crossbows aren't considered a weapon as far as in that criteria.
Oh, there's compressed air rifles out there now that they've been approved for moose hunting, so.
Yeah.
I think we just need
Oh,
to
and there
add
are
that.
BB guns that look like a pistol. I mean, and then
Yeah.
you get into if it looks like
Yeah.
one,
Guns. Yeah.
how can you tell?
Right.
Whether it is.
Well, in one of the definitions I found, there's even one that includes the minimum amount of compressed air by joules that would consider it a firearm.
Wow.
So,
Huh.
for those that a CO2 cartridge that produce a certain velocity, they're considered firearms, where a BB gun wouldn't have that.
So would someone like to rewrite our definition to submit it for next
about-
staff meeting so we can submit it for approval?
Yep.
How about no weapon that, no, that would be a bow. I was gonna say, how about no weapon that
Appears as
produces
like,
a projectile? But that would eliminate bows.
I'd be happy to work on that, MJ.
Okay. So I'll put, we'll leave this as an action item for next staff meeting to
Okay.
bring back up.
All right. And Tom raised the issue that we talked a little bit about on the release by DOC and then no release plan, and then how does the board react to that kind of thing?
no, my only comment is this: is the case we had was a guy that was ready to go out, had a job, place to live, everything in order, and then they said, well, no, that because he's now RSN, that they had to wait for time while he's incarcerated or while he's got. I said, well, how much time would it be? Well, we don't know. I said, and I asked, well, would he be? I mean, is it a month? Is it a year? They said, we don't know. And then I asked, well, did he have a plan in place that you guys approved of? And the PO and that down in the southern part of the state said, well, we don't understand. She didn't understand it either. So at that point, we paroled him, and I have no regrets on that decision at all. So, but
I think it's going to be helpful to have some discussion on that whole RSN risk containment issue, because it seems like in many cases, risk containment is handled by a different group of people that were not involved in the original either case planning or case staffing, and it comes subsequent to that all.
They are.
Yeah.
and my point has been, so what's going to change 6 months from now, as opposed to that's what I mean,
Right.
as opposed to now.
Right.
You know, something you probably lose his residence and won't have a job.
And this
Right.
may be a higher conversation that we need to have between chair and commissioner as well, because it is the executive committee. So we may need to go up a level at DOC. I think getting the overview to find out what the actual process is, who's making the decisions.
Yeah.
Maybe is there more information that the board needs that the executive committee may be getting that you are not all getting? Is there information in the packets that we are missing? Think about that in making some of those decisions as well.
Well, and I
And-
think it's hard when it's presented because the case that Tom's talking about, the supervisor in the southern part of the state was like, I don't know why he was denied. Both the caseworker and the parole officer said they have no idea why he was denied.
Right.
But they were going to have him sit in jail for an entire year and then review it next July.
Yeah, so
And
I
they
think
could, Yeah, well, the other thing
So-
was, MJ, they also said that in this case, they asked them to explain one line in the case staffing. They couldn't do it, which was what's
Yeah,
holding
and
it
I
in.
think these are gonna be the perfect questions in that forum.
Mhm.
So jot your questions down. And if we can, I'll take some of these that just came up and I will pass those on. If you have any others between now and like February, like the second week of February around President's Day, let me know so I can give them to DOC so they can come prepared with what your questions are and we can get them to them and they can incorporate that into the discussion.
Can I give
It's-
you one right now while I'm thinking of it?
Yeah, put it on the record and then I can just look at the record after.
What training are they doing in the field and the facilities for when the caseworkers and probation officers are presenting? That's a question that I have, because more often than not, I'm hearing, we don't know, we don't know, we don't know.
Yeah.
Sorry.
No,
Yeah.
don't apologize. That's a good question. Absolutely. Then they can prepare and get these answers instead of sometimes when we have people in front of us, we forget or
Mm.
and we're
It's-
going to be in person in February. So that I'm hoping that Jordan will be in person with us.
It's important too to know and to look at our SDMF information that we developed. And certainly central case staffing is typically done when those cases are assigned RSN or risk containment. And there's a lot of good information in the case staffing. And it's not about us going against corrections. It's about us making decisions based on the information we have that can be supported. And then assigning the conditions that if we grant parole that are risk related, period.
So would it be helpful if I looked at some of those cases and just brought them to a future staff meeting, just so we get an idea of what those are and looked and brought the SDMF forms with them so we can kind of see what some of those SDMF forms look like and some of the justifications for the grants, just as kind of another check and balance of our decision making.
Yeah,
That would be great,
absolutely.
MJ, case, which you know I'm talking about, he also had done tons of programming.
Oh, I
Yeah.
haven't been writing down the cases, but every time an RSN is released, I do send a professional courtesy email over to central office so that way I get ahead of it before it comes at me.
That would be a great one, because I'd love to explain that he had no DRs, he had a job, place to live, did tons of programming. He rang the bell, and he was ready to go out. And then they said, well, we're gonna keep him in for some period of time to see how his behavior is.
He waived his hearing in July, his minimum hearing in July, thinking he was getting out on furlough and could get his time, and then wrote to the board to be seen later after they made the decision to keep him in for a year.
Yeah, that would be a fun one to discuss, and
Yeah,
especially when there was no rhyme or reason why they were doing it, keeping him in. They said, well, we just want to see how his behavior is going to be.
And they couldn't give any justification for it.
No.
I
Good.
think that's definitely a good way to look at it is bring
I
these
do too.
cases for
Yep.
discussion, look at the SDMF forms,
yeah,
because I'm also curious to see how they coded.
yeah,
Mhm.
yeah. I'm anxious to hear from Jordan too and what their
Yeah.
process is. Yeah,
I apologize for not doing it sooner, but
no, that's okay.
No.
I figured we had
We'll
a big
get there.
agenda this time.
Yeah, we'll get there. Parolee subsequently sentenced on a new charge. Murphy case is an example.
Yes.
Because nearly all of us were involved in that one from the beginning to the end. at some
Probably.
point. But this was someone who was on parole, picked up a new criminal charge for domestic assault. Case was postponed, ultimately heard by the board, and continued on parole. And then, while on parole, the offense, he reached a plea agreement with the offense. He picked up another new charge of possession of cocaine. And so a plea agreement had been reached. However, the plea agreement effective date was the Tuesday after we had the hearing, as I recall, MJ, right?
He was going to be sentenced on the Tuesday after the hearing.
Right. And so we had the parole officer provide information to the board that this person was doing well, and he recommended him staying on parole. And the sentence, I believe, was concurrent with his existing sentence, so there wouldn't be a new minimum, but there was a different maximum, wasn't there?
There was a new minimum. It was just satisfied with credit. So anytime they're
Okay.
sentenced and they get a new minimum sentence, there is a new minimum. It just happened to be satisfied with credit because he'd had enough credit for time served. His maximum was extended.
Okay, and you and I had looked at a statute that we thought might apply in this
Yep.
case. Making a decision prior to the actual
Sentence
conviction.
date.
Yeah. Anyways, it came back after we supported that they were not happy with it. And then ultimately they were holding this person until after the actual sentence on another matter. And then we saw him the following month and continued him on parole.
With the they,
So let me,
I don't
think
have the
this
case
is
in front of me, so I'm just trying to remember it.
so this is a greater issue, and I want to, that's the specific case, but it's not the only one that's happened recently.
Right.
And I touched upon this a little bit earlier. So I think one thing that we need as a board is to figure out, and this was another topic I was working with Brendan on, that kind of has gotten put on hold, is there is a statute around service of a term for an additional crime. The question comes at hand. So somebody's on parole, whether or not they've had a violation or not, they're on parole, they pick up a new crime. They are subsequently sentenced on that new crime. Are they automatically on parole for that new crime, or what is the mechanism for that new crime to be integrated into their parole? That's the main policy question. And it's happening a lot more lately because the courts are starting to catch up. So in Murphy's case, this crime was from 2022, this domestic. He was seen in the board in 2023, continued on parole around that domestic. Subsequently, in 2025, he picks up a new cocaine. They decide, I think they dismissed that cocaine charge, sentenced him on the domestic. Then he's brought forward for a violation on the cocaine charge and some other stuff. And then how do we integrate that domestic into his parole agreement? Because it wasn't part of that latest violation.
Right.
So here's the complicatedness, and this is what I'm bouncing up against more and more, is technically, if somebody picks up a new crime, if they're in the community on parole, they have a new sentence on a new crime, that new crime, if they're in the community, they would be on furlough for that one sentence and on parole for the rest of them. They're incarcerated, they'd be incarcerated for that new sentence, they'd be on parole for the rest of them. Dual status. It's confusing as all get out. So then it comes into the statute of 28,554 that says the board may permit any parolee who commits a crime while on parole and who is convicted and sentenced, therefore, to serve the sentence concurrently with the term under which he or she is paroled.
That's what we were looking at. Yeah.
Yeah. So the question becomes is what's the mechanism for that new crime to potentially be put on the parole agreement? Is it an administrative review by the director or the chair? Is it a new minimum hearing? Is it based on the severity of the new crime? What are the factors in all of that? And that's, for a while, I was doing this with DOC where if the person was remaining on furlough, we would just incorporate it into the parole agreement. Now they're looking at their cases with higher scrutiny like in the George Murphy case, and they actually reincarcerated him on the new crime. And then we had a minimum hearing to decide. We didn't actually decide if we were going to revoke the parole or not. We were deciding if we were going to incorporate that new charge into his parole agreement. And I know I probably just said a whole lot that confused all of you because it's confusing.
I
Well,
got
and
it.
this one was tricky too, because the board 2 years ago had made a decision on the new charge to continue him on parole. So that matter for us
Right.
had been dealt with. So the new matter was the possession of cocaine, which, as you're saying, had been probably dismissed in the plea agreement. But that's what was brought forward for us to look at.
And then, so the other thing I'm trying to do, and we had one of these last week, where we had a parole violation that came before you all. The person had been sentenced on the new crime, but they had a new minimum sentence that was in April. So I'm hoping, this is something I think we need to tell DOC is if they've been sentenced on those new charges, don't just give us the plea agreement.
Yeah.
Give us a new sentence with a new minimum release date. Because what triggered me was that plea agreement, and that's when I went looking at his sentence structure. Because it's the plea agreement's one thing. That's just saying I'm agreeing to this, but it's not the actual sentencing document.
But in that case, the board agreed, we're not paroling him. He hasn't even reached his minimum yet.
Well, you were revoking him because of the new charge. You put that in, you put that new sentence in your decision making. So that one's a little bit different because we waited to hit that violation, waited for the court process.
Okay, with Murphy, I would say when he was sentenced on domestic, we had granted him parole with that charge pending. When a sentence of time served, I think that would be fine. The cocaine would be another violation, which they could have brought up as a one violation.
But they had brought that up, Tom, and that's what. So the board, so what happened is the board continued him on parole for the cocaine possession one.
Yeah. Mm-hmm.
I was at fault for part of this too, is that we presumptively paroled him to that new sentence before he was sentenced on it.
Yeah, I got
and we
it.
knew
that's
that.
where
We were
came.
just trying to support the recommendation and work this out.
The PO supported that decision, if I remember correctly. But I see, I got it. I got it.
And the supervisor was not in support of that decision after the fact.
We found out after the fact, and then.
Oh, I didn't know that. Okay.
Anyways,
I just say.
So that's another thing on my list of how do we build, because that's something our manual doesn't talk about, and it's something that it should, and it should be a consideration in your violation decision making too.
And it would come back, it would be helpful in that case too. And I know I could have looked it up. I don't recall that I did, but to go back to the violation hearing of a couple of years ago, when that board continued him on parole, to listen to what the rationale was for him to continue that on parole, and then understand that what happened in court was the plea was for the domestic assault, and the cocaine charge was dismissed, and the sentence was going to be concurrent, but it hadn't taken place yet.
And that's why I think it's going to be important, really, to state a lot where our findings are going to be really important when looking back on these, and to make sure that it's clear on the record and in our paperwork. Why? Because a lot of conversation happens in deliberation, which it should, because you're deliberating, but making it clear to all parties at the end. So when we go back and look, because you're not privy to your previous deliberations.
Right. The decision write-up is important. Yes.
Yep. And even what we put on the record, I think, is important too. Because the record is often used more in litigation. The transcripts of our records are used more in litigation than sometimes our paperwork.
Yeah. Good. Anything else on that, MJ?
Nope, just putting out some of the stuff that is coming up daily or weekly.
Oh,
Regularly. Subpoenas, is there anything else you want to add to that?
No, I would just caution that we have the ability, but I would really look at
The seriousness
all
of it.
factors of the case. Has confrontation been requested? Is there a postponement request pending? What are the factors? Is somebody opposing the postponement request? Really looking at all the factors in play and also realizing that it's going to take time to have subpoenas issued now if we are issuing them, and it's going to have a fee associated with it, and it's not something that we currently have in our budget.
What, why a fee is necessary?
Well, the sheriffs are going to charge us to serve those subpoenas.
Anyone can serve a subpoena, and I don't understand why VOP or the probation officer can't serve the subpoena.
They won't
And
do it.
that's
so-
not a
They're
that's
not
not a
doing it
conflict.
anymore.
That is not a conflict of this whole thing.
they won't do it.
They will not do it.
No.
So
Why?
our statute says subpoenas so issued may be served by a parole or probation officer or a law enforcement officer in the same manner as similar process in criminal division of the Superior Court.
Okay, well, in that process, anyone can serve a subpoena.
Right.
Well,
So it's
DOC will not
it's gonna
serve
fall upon
subpoenas.
us, Wayne, and
Yes.
Yeah.
Well, Wayne, you want to be a subpoena person, you could do that, I suppose.
Well, I'm seeing that the way this whole thing's going, we're gonna have to be like other states that have parole board investigators and process servers, and
Oh, yeah.
it's gonna be incredible.
yeah, I think it's going to be important to have that meeting with Emily and talk about a process going forward, but we're going to be more involved in violation hearings than we have been. And I feel bad about that because I like the process that's developed, which Lori helped initiate, and now we're going back to where we were.
She won't take ownership of it though.
Motions, MJ?
Just
Did they come back to you?
no, it did not come back to me, but go ahead, Sam.
Sorry. Was it the conversation that was had, I think last week or the week before, with the board with people not feeling comfortable making motions in the wording and creating the sheet for that? Is that part of it?
Yes, I think it was that. I think it was around creating a motions cheat sheet.
Oh, that would be amazing.
Around what motions to make.
I would love that.
I think that's exactly what it was. Thank you, Sam, because I was tapping you a little bit because I know you have a cheat sheet.
I made my own cheat sheet when I got on the board years ago. I had my own cheat sheet, absolutely.
Yeah.
Well, share it, Tom.
So I think that's what it was
Very good.
creating a
I have
general
it.
cheat sheet for the board to have in making motions, because for some people it rolls off the tongue a lot easier. The other thing I wanted to bring up, and I'm going to look at you, Dean, for your expertise, because sometimes a motion is made, then I see deer in the headlights by the other member of, I don't really want to second it.
Yeah.
What happens if I second it? So I really
So,
I was hoping you
there
can
should
touch
be-
upon that.
Yeah, and the whole thing with motions and so forth is using Robert's Rules of Order to help us guide through our decision making. We're not required to do that, but we have since I've been on the board, and I think it works well to serve us well. But as MJ has said, if a motion is made and it is seconded, it should be followed with any discussion. So if a motion has been made and seconded, and there's discussion about it, if someone objects to the motion or says, boy, I'm not comfortable with that, I'd really like to have had, a deliberative session or whatever. First of all, there's three of us typically making these decisions. So that person is probably the one that seconded the motion. If the motion is not seconded then it fails for lack of a second. And then the chair should ask for another motion. At that point, it would be appropriate for someone to move to enter a deliberative session and then go forward. But if the motion is seconded and in the discussion, we find that, well, I really want to have a deliberative session. As chair, I would say, yeah, I would agree with that. And then you can either ask for a vote on that motion and it would fail by a majority vote, or the maker of the motion could ask to withdraw that motion. And you could move in that direction. But there's ways to deal with that. But essentially, if you're not comfortable with the motion and you're part of that board, don't make the second.
If you
So
second it, you can still ask for a deliberative session after that.
If
So we can
there's
second
no
it, you can say, well, I would like to
chair
make a
could say
make a
if there's
motion.
no second, then the motion fails for lack of a second. Now, the chair can second it if that person feels strongly that they want to move forward with that. And then there could be discussion, and that third person could say, I'd really like to have the opportunity. I'm not comfortable with this or whatever. And then those group of three have options. They could move forward with the motion. If it passes 2-1, then it moves. If it fails 2-1, then it would go to another motion.
So
And I
if
think
we,
Oh,
so if
sorry.
we don't want to second it, we should just, so like, let's say it's Tom, Wayne, and I, and Tom makes the motion, but I don't want to second it. I shouldn't say anything and
Right.
wait for the chair to say
Right.
it fails.
Or the chair
And
would
I
say,
think
is there a second? And if no one responds, then as chair, I could second it, or I would say the motion fails for lack of
Okay.
a second.
Cause that's what
And
I
I
was
think-
wondering, like, do I jump in, if I don't want a second, do I jump right in and ask for a deliberative session, or do I just say nothing?
Yeah, I start off by saying nothing. But
I think
Okay.
that's
Go ahead.
important because I think sometimes we get, just from my observations, we get into the habit of we're just moving.
Yeah.
And I think there's always an assumption. And I think I like what you just said, Dean. And I think it's important because oftentimes if there's not a second, the chair then doesn't ask for a second. Sometimes the chair then goes, could I have a motion for a deliberative? I think we need to really look at that motion that is on the table first
Yeah.
Mhm.
and then let it fail first for lack of a second and really putting that on the record. Because I think we often just get into the
Mhm.
rhythm.
That makes sense.
And I think we often forget about the discussion piece of motions too, in between a motion and a vote too.
Well, a lot of times if it's a 3-person board, someone moves to go into a deliberative session and someone seconds it and the chair agrees, there's no need for discussion. Just move
No,
on. Yeah,
which I think I'm more talking about like
I know.
when you get that reluctant second,
Yeah,
because you can hear
yeah.
it in the person's voice.
Right, right. And say, okay, let's talk about this.
Yeah, exactly. Because
Yeah.
I can definitely hear it in some of your voices when it's like,
Yeah.
I don't know. I think you might have jumped the gun a little bit.
So is
Yeah.
that something that you want us, now, like I'm chairing 2 days a week and then Pat and Dean, is that something that you want us to ask? Like, is there any discussion on the motion? And then call for
Well,
the
that should always be
favor?
asked. Yeah.
Okay. I don't ever ask that. I've never asked that.
Yeah.
But I don't know anything, so this is new.
Yeah, no problem.
Well, and that's why I want to eventually, it was something that Steve had asked for. I eventually want to make like a Robert Rules of Order cheat sheet or something to that. Just a quick little cheat sheet for any board member to know how this works. And for anybody who might be thrown into chairing as well.
Yeah.
And a good refresher for our chairs.
I know a lot of times too, before the hearings start for the day, some of the boards I've been on, the other two will say, who wants to make the motion today, you or me or whatever. And that's fine, work that out.
That makes
But-
it easier because you have that dead silence, who's gonna do it? So it's always better to,
Yeah.
keep things moving, as MJ said, things moving along, so you know who's gonna do it.
Yeah.
Good discussion, yeah. Good, okay. Legislative updates. Sure where that bill is at this point, but
It is
Um,
I believe it's in second drafting.
okay. So
It hasn't been drafted. I think that's where it left last
Yeah.
week.
Yeah,
I don't, go ahead, MJ.
So just to give an I figure we could give it just a general overview and then we can get into a little bit more of our testimony. So the House Corrections and Institutions Committee, the chair wrote House Bill 559, which is kind of what has instituted a lot of general parole discussion. So before the bill was even taken up, I was called into the committee 3 times to give overview of parole. What is it? What do you all get for training, etc. I will go over some of that presentation in the next item in the data, which is kind of Parole Board 101 again. So the committee started out that way. Then there's House Bill 559. There's Senate Bill 237. Senate Bill 237 is still on the wall in Senate Judiciary. It has not moved at all. That bill is one that I don't know if any action will be taken on. It's a really aggressive bill to basically make the board a full-time board. There's no support. There's no monetary support for that. It's a very aggressive bill. I don't imagine, if anything, parts of it might come up in the House bill. In the House bill, I think is the bill that's going to move. I'd look at Tom and Dean for your opinions and just to also look at your testimony towards that. I don't know if any of you read the bill.
Yeah.
It is coming in second drafting. It's really around training for board members, potentially looking at term limits for board members. The other thing that I looked at yesterday, I'll just let all board members know, is that we are one of the only quasi-judicial boards in the state that have 3-year terms. Most of the quasi-judicial boards of the state have 6-year terms. And I found that to be very interesting that we have 3, but all the other quasis have 6. So I found that interesting. There's also pieces, there's pieces around making, getting rid of the word alternate for board members and just making it a 7-member board instead of 5 members with 2 alternates, which then presents some language around quorums, but I did find some other language in the labor board's statutes that would help that. So it's maybe in expanding a little bit more of the role of the director in statute. Those are the big overall arching topics of the bill.
Yeah.
Tom and Dean were invited in last week for their opinion, and I'll divert to them to kind of present on their thoughts.
Tom, do you want to begin?
It's interesting the knowledge that the sub-members of the committee has and doesn't have, which is always interesting. I do regret not mentioning about the director's term. I thought that was ridiculous to have the director only have a 6-year term, a 3-year term?
It's a 4-year term.
Yeah.
That has not changed, Tom. That's current statute.
We had, but they had mentioned that in the bill that they were looking at having that lessened, or just have 1 term, wasn't it? I think that's what I read. Oh, never mind.
That statute hasn't changed.
Okay. I think we were okay. I think Dean and MJ did an exceptional job. I mean, they covered it really well in the history, and I think the training piece was something that they were very concerned about. But again, MJ also said it costs money to train, and I think they got that. And the other thing about was I think loud and clear that why are we under the umbrella of corrections for financing? And I saw the look they got when MJ said she had no input in her budget this was the first year she had any comment, any phone call. I think that made a huge impression. I don't think they realized that it was all that. And I gave my standard answer to my computer has a DOC stamp on it. And I think that's something that might change. But other than that, I thought it went very well, and I think they're very interested. And I don't know what the bill's going to look like when it gets all said and done, but it'll be interesting I've been watching it to see what the second right will be. So, but if they take us out of corrections, there has to be some money that goes along with it. what's the budget? MJ doesn't know. Dean doesn't know. We just get paid, and this is what we have. So, and that means it will come out of the corrections budget, which is something they count on, I'm sure. But other than that,
So I kind of went through a number of issues in the bill that I had questions about and a couple of concerns, because this is essentially a rewrite of 403, 28-403, which is existing statutory language. And my initial concern was 403 has not changed since the director has become a position of the board and not an employee of the Department of Corrections. And so it still has as its title that the responsibilities of the parole board are the commissioner of the Department of Corrections, which should not be the case, especially since a lot of the language and statutes recently have proclaimed that the board needs to be independent so that it is not tied to the Department of Corrections or any other agency for that matter. And so the discussion then came along, because that's more complicated than just changing it. There's other issues that the Commissioner of Corrections has to be responsible for. But my thinking was that if it's going to be the responsibility of an agency, it should be Human Services to some degree. And then the director's position, which is clearly statutory new language, would continue to say that that person is appointed by the governor for a 4-year term with consultation of the board. And training, we talked a lot about that. The comments I made, I felt that the chair and the director should collaborate on the training together. There are some training options that require the chair to be involved in initiating or supporting. And there are a lot of things that the director does in that regard. And I think the two of them together would make more sense than just having it be the responsibility of the director. The term limit thing, I didn't support that. I explained that, this is a decision of the governor. And, if the governor chooses not to reappoint somebody, then they may be there for one term. If the governor's office wants to reappoint somebody for whatever reasons they have, that should be the governor's decision. And then term limits, may be a good thing in some arenas, but I'm not sure it would be in the parole board. And if the governor would support that, I would be very surprised. The whole thing with 7 members as opposed to 5 and 2 alternates, we've made that argument before in the past. And since I've been chair, and I think you all know this, I don't treat anybody as an alternate. I treat everyone as an equal in this matter, and everyone gets scheduled the same amount. And so we don't make a distinction, but statutorily it's made a distinction. There's no other difference than in that statute. And as MJ said, if it affects the way that the definition of a quorum of the board is made, it says now that a quorum of 3, because that would be 3 of 5, you can change the statute to reflect that a board of 3 will, have something to do with conducting
And before
hearings.
you move on, Dean,
Yeah.
I had made that suggestion because I'm more trying to protect how the way the board is running, because if a new
Right.
chair comes in, a new chair may decide to use it as a 5-member board with the 2 alternates being truly alternates. So
Right.
it's more of I'm trying to protect the way that we've been doing things.
So, and you're right. When I started on the board, that's what was happening. There was 5 of us at hearings, and if one of us couldn't be there, they'd have an alternate. And Pat, I know you did that for a couple of years. I couldn't believe it. I mean, you're sitting in this line of 5 people, and by the time anybody got to you, if you were the last person in line, everything had been said about 9 times. And so the statute did say that a quorum of 3, and that's when we moved to that became our standard operating practice. So that could be incorporated in language in the bill. I don't see that as a hindrance.
Yeah, no, I just wanted to kind of state why I had suggested that change of just trying to protect operationally what we've established because of the workload. It would be, to me, it would be a huge lift if that quorum of 3 could only be of the 5 unless we had to throw in an alternate from here or there. So I just wanted to throw in a little bit of where I was coming from when I suggested
no,
cleaning up that
absolutely, MJ.
statutory language.
Yeah, absolutely. Because, with 5 being required at each hearing, you'd be doing 3 hearings a week, everybody.
Yeah, or having a quorum of those 5, 3 of those
Yeah.
5, you'd be doing more than 1 hearing a week.
Yeah.
And then the alternates would only be called in periodically.
So there were a lot of good questions from the committee members, and I felt good when we got done that they had a better understanding. I'll be interested to see their rewrite, if they've taken any of our suggestions to heart and included in that.
And another piece that they were interested in too, and I started doing a little research because some other boards have it in their statutes, is around not just having it as a governor's appointment, but actually having kind of a process, like a vetting process integrated in prior to it getting to the governor's level.
Yeah.
And having some kind of vetting process, because there's been times where we've been involved in the vetting process. There's been times we haven't been in the vetting process. So it's more
Right.
of same thing around reappointments, around vetting or not vetting and how to do that.
Yeah.
So that was part of the discussion as well. I know there's a new legislative counsel who is assigned to that committee, and it may take a little bit longer for a draft. I'm not sure exactly. The committee really knew what they wanted in the draft, but I've been watching for the new draft to come along.
And I don't know if the administration has weighed in on this at all or not.
So the general counsel, Jay Pershing Johnson, did email me, and she had no objections to the original right of the bill. She did ask what she did ask me around who would be the change in language around the board members' qualifications. Can't remember off the top of my head what it is, but I can tell you in a second. Who would qualify for that? And I just said we were modernizing the terms, not changing qualifications in a way, but really focusing on having some background in criminogenic need areas, substance use, mental health treatment, really the factors that is coming before the board to try to prevent having individuals come in who have no experience with the clientele that are coming before them.
Could sneak in something about the pay too, because they weren't happy about the pay.
Oh, we've been talking about pay. Yes,
They're just
we've been
sneaking in the
talking about
bill.
pay. We've been
Let's
talking
put a
about
little-
pay for board members. We've been talking about pay for the chair. We've been talking about that as a whole. There's been budget discussions around whether or not the parole board should be its own budget by itself, which then has other issues that stem into, would we then need an accounting staff? Would we then need personnel? What would our budget look like? Because we absorb a bunch of
Yep.
those, which I did find out more about our budget yesterday, because now I'm having quarterly budget meetings with the
Good.
DOC budget folks. So I did find out what our last year, what our actual appropriation was, and what DOC decided to allocate us, and where the difference went.
Interesting.
So I am starting to have more of those budget conversations. I will say they are very happy with us because I tend to run a tight ship when it comes to the budget. I like to be frugal. We are right now, this is a little off topic, but we are right now in place to be able to send 3 people to the Association of Parole and Authority International Conference again this year. I'm hoping it's going to be myself, the new chair, and a member. I'm kind of going down my list from last year of who was next in line, who showed interest last year. And we're still in the black. So, and that's allocating out our per diems, looking at our potential travel for in-person staff meetings. I'm starting to really learn how to do the budget process that I haven't been doing these last 6 years. 7 years, I should say. Wow. I hit 7 years this month.
Wow. Seems like only yesterday.
I said, is it
Good
COVID?
news.
Since COVID, it's been a blur.
Sure has. Any questions on the bills? Any of your own thoughts on something that we might want to address?
I was
I
gonna
thought you
bring
all
this
did
up
very
back
well.
round. Oh, go ahead,
So,
Wayne.
Pat,
I just
I
was
was-
saying, I thought you all did very well, and I watched MJ's first appearance before you guys. Seems like they certainly are cracking the door around pay and autonomy, which I think is fantastic. What's Alice's background, MJ?
Dean, do you know?
yeah, she's been in the legislature for almost 30 years.
There you go.
She has no corrections history?
She's been on that
'Cause-
committee
Cause
for,
Okay,
she was,
she was the vice
Bob
chair with
Wood's
Bob Wood.
vice
Yeah.
chair. And she's been chair ever since Bob left.
Yeah.
So that's, her history is with that committee.
Okay, because the first one I watched with MJ by herself, MJ would start and all of a sudden she'd jump in and just take right off explaining to the whole committee the answer to the question. I'm like, MJ.
Yeah, it's walking
No,
that
and all
fine
was
line.
good.
It's walking that
Yeah.
fine line, Wayne,
Yeah.
of
But she's
when
a-
you
she's a
disagree
strong
with the
supporter.
chair and when do you not disagree with the chair.
Oh yeah.
I
She,
will say the committee has been in good moods. I've been privy to some of their conversations behind the scenes in Zoom beforehand. They have been in great moods. They've been very welcoming of us this year, of me. I mean, I'm
They are
taking
good
advantage of their good spirit.
Yeah.
That,
And I can definitely send out the second draft when it comes out if you all are interested. You all as members are more than welcome to, I would suggest submitting feedback to Dean and I, and then we can figure out if the mechanism is for you to submit it yourself or if we submit it from as a board standpoint.
absolutely. They like hearing from us. Pat,
Pat,
Right now.
Maybe not.
I was gonna bring this up at the round table, but I'll bring it up now. I was kind of disillusioned when I listened to all of you testifying that nobody on corrections, nobody at the legislature, it's like they had no idea what the pro board did. And I'm thinking to myself, you know what? If they're concerned, why don't they attend some of the hearings?
I told them to.
yeah, we've invited them, Pat.
Oh, I know, for
So-
years,
This-
but now they're interested. What
No,
do we
so-
do? Why do we do it?
But you
So
got to
here's the
remember,
thing,
this,
Pat. You all have hid so well for many years. There's a lot of people that are interested now. I'm trying to get you more FaceTime and for more people to realize how much work you're doing. I'm trying to advocate more because I think you guys have been a machine that has just been functioning out of the limelight. And that's part of it. And
Yeah.
that you've stayed out of the press, you've stayed out of the courts, you've been just functioning, doing, and so it's that kind of stuff.
Yeah,
And
it's
why?
I guess it's just, I think we're an important board, and for them not to know how we function is concerning.
Well, it's like Vermont. I mean, the thing is, why we're under the auspices of the corrections. Nobody's complained. It's been running fine. Why are you rocking the boat? So
Yeah.
that's how. So things are going fine. So we just keep going status quo, and things will be happy. Everybody's
Yeah.
happy.
they are interested, Pat, which is a good thing because this committee has a lot of, they are responsible for the capital budget for the state.
Right.
And that's their primary function in the legislature is to put together the capital budget, which is huge. And this is kind of an ancillary part of their responsibility. So,
Well, it's
they
nice
get new
that they're
members every
taking an
year.
interest.
and every year they get new members, and the chair's been good about inviting MJ in with her Parole Board 101 presentation, and
Yeah.
new members learn about the board, and as they go to other committees, they take that knowledge with them.
I wish they'd
Well,
come to a couple of hearings.
I told
I'm
them they
glad
could
you
also
didn't offer
request the
up any-
recordings too.
Yeah.
Yeah. Wayne?
no, I just saw one of them make the comment that I can't believe somebody do it for that kind of money. It's ridiculous. And then you talked about the other high price states. I'm glad you didn't throw in that, like, oh, I don't know, Idaho volunteer. They're volunteers.
I like her
Yeah, but they get paid
$2 an hour comments, one that I like.
They're paid, but they
Or
get
Montana,
stipend.
I guess. Montana
So-
volunteer.
So
Oh
the
my God.
closest board to us, from my experience in the executive directors meeting at APAI, is Wyoming. They
Yeah.
are almost similarly run. I think they have a bigger office than we do, but their board pay, everything is pretty much the same.
Can I take a
Okay.
bathroom break?
Keep everybody posted. What's that?
You
Can I
can,
take a bathroom
Yeah,
break?
go ahead, Pat. We're moving on to the
I gotta make
data
a motion.
presentation.
You need to make a motion, Pat.
I'll make a motion, we take a
Just
bathroom break.
disappear.
Yeah, just go.
A second.
So on the data stuff, MJ,
yeah, I didn't, I just posted it this morning. I wanted to,
Oh, you
I was
did,
hoping
okay.
I could have like 15 minutes just to go through some highlighted points that I had for
great.
you all.
Yeah, I didn't see it. I was looking for it. That's all.
Cause I sent you both, it's basically, it's one, it's not complete. It's basically what I had provided to the legislature. So
Yeah.
give me a second and I will pull it up. And I'll share it. I just want to hit a couple points of.
Good.
Come on, computer. Ah, wrong button. I think I know where all the Teams buttons are by now. So basically what I'm presenting is what I brought to the legislature. It's what I brought to the legislature with a couple slides that I brought in another presentation to the legislature. So it's a couple things that I want to hit on. So just bear with me while I'm just going to jump ahead a little because I don't think I don't need to go over the general information, the hearings and so forth. As you will see, the total seen numbers are not updated. We saw 666 individuals last year. The one thing I want to look at is I want to talk to the board about, is the total number seen an important number? Or is the overall how much activity is coming before the board more the important number? Because I know this has been something that's been tracked over time of how many individuals are actually being seen, where we've had less parole violations coming before the board because we have proposed resolutions. So you're not actually seeing the individual, but it's still a case that's coming before the board. Record reviews are not counted as seen because it's an administrative function. So to me, is seen really the important number, or is the activity of the board, the amount of cases, more important?
Absolutely, the activity. Absolutely.
Okay. And that's what I was thinking. So this one, I didn't update as much, and something that I wanted to just put out there. The other thing to note is the interesting piece is our waiver numbers for parole hearings were almost identical. Between the 2 years. I'm just opening up my other presentation on another screen so I have my little notes. That's all. Because I have some notes in my PowerPoint. So I just wanted to point that out. Our total parole hearings were down this year. But to go along with our total parole hearings, our grant rate was down this year. Our grant rate went from 60, I think it was about 62% down to 49%. And I think that's just showing, I don't look at that as a bad thing. I think it's just it's reflective to the population that is before the board. With justice reinvestment, there's been a lot of changes to the correctional population. People are getting, the lower level cases are being diverted. They are not coming, they're getting probation sentences. The people that are incarcerated are the individuals who have been around for a long time. They are your repeat offenders. They are your more severe crimes. So I think that's just more reflective of the actual correctional population, not so much necessarily of the decision making of the board. I didn't delve into, I haven't had a chance to delve into how many low risk versus high risk versus moderate risk that have come before the board, but I will say the majority of the individuals that the board is seeing is moderate or above.
Right.
You're not seeing the low risk offenders anymore
Which
very often.
in the days of high numbers, the majority was low risk, which we just don't see anymore.
Right. So I just wanted to throw that out there. We only had 3 presumptive parole cases last year. That's again reflective of the population. They're not meeting the criteria for presumptive parole because the criteria is stringent and it's just reflective of who's incarcerated. Not going to go into the whole detail. There was 175 annual reviews last year. 48 of them. There was 175 total annual reviews. 48. On top of that, 48 requested to see the board, and then the board requested to see 5 people. I know you requested to see more than 5 people, but I don't have the numbers of who then denied your request and chose to not want to see you. So I have not delved that far into the data. So some of the 175 are the ones that you wanted to see, but then declined your invitation. Reprimands. We didn't have a whole lot of reprimand cases. I don't know if this is a big change from 2024. I'd have to look. I think this is something that we could look at in policy. One thing I kicked around with all of you is looking at our violation process, also looking at our reprimand process. If a PO wants to continue somebody on parole, let's hear it as a reprimand first. Then the board decides if they want it to be a full-blown violation. I think instead DOC is just bringing everybody mostly forward for a violation hearing.
That would help out with the new process for violations too.
Yep. And as you can see, the reprimand process is being used mostly for technical violations.
Yep.
So now we get to our violation hearings. Our violation hearings have significantly increased. We had an additional 30 hearings this month and this year. And this does include the proposed resolution number because I didn't know how to factor those in yet because I hadn't had time to really think about all of that. And again, you're looking at 52% of them are technical violations. I think and if you look at these numbers, it shows the nature. I'll have another slide in a few minutes. It'll show the nature of the things that parolees are encountering out in the community. It'll show you the struggles around housing, substance use, mental health, and it ties. There were very few that were just there for a sole committing of a crime. We had 34% that had both new offense and technicals. Generally, there's something else driving why they're committing that new crime. And I bet if we really wanted to dig deep, these sole new offenses probably had other factors. The POs just brought the new offense. And also last year, there was two hearings where the board took no action. So the violation just stopped. And there was one, and one of those was a technical and one was for both a technical and a new offense. And 41 individuals waived their parole violation hearings last year. I think we've started to see a little bit more uptick in violations towards the end of the year. I think we've started to see a little shift with the attorney changes. I know I've seen a few. seems like we're more consistently having a violation waiver, 1 or 2 a month now. And this just kind of looks at the by type and outcome. It just kind of shows technicals, the green are your continued on parole. So we continued more folks with a technical violation than revoked folks with just technical violations. New crime, we actually, for new crime, there was a lot of new crime folks that were continued on parole. And with both, it's kind of reversed and more were revoked, but I think it's really you're looking at the totality of the cases. And then I just wanted to show the waivers. And if you look at it, most of the individuals that have both new crime and technical violations are the ones waiving, which makes sense.
Yeah.
So then this chart is the chart that the legislature was asking me questions on, and I'll try to increase it a little bit without cutting it off too much. They were asking what violations were they committing? So my caveat before I start talking about this is these numbers will not add up to your violation hearings. I had no way to figure out how to trump I didn't want to make a whole order of hierarchy of which condition trumps which condition. So what I did was I went through every violation hearing last year and looked at what conditions were violated. So just so you can get an idea of what is coming before the board for conditions violated. And this is the ones where there's sole one condition, or it could have multiple conditions. So I just thought it was important just to see the committee was really interested in what they're looking at. What are the factors into violations? What community resources are needed? What are the challenges for individuals out in the community? They know it's not just the supervised population. They know it's the general population as well, but they're really looking at substance use, mental health, housing. What are all of those factors?
So MJ, can I ask a question about this?
Of course.
The purchase, possess, or consume of illegal drugs. Is that separate from, or is that also altogether lumped in with a new crime?
It's all lumped. So it could be lumped in with a new crime. So basically 87 individuals that came before the board for a violation. One of the conditions violated included purchase, possess, consume illegal drugs. I don't have a correlation of how many have the new crime too.
So that could, but that's not, so it's not everyone that, it's not, so that's only if that was a separate violation.
If it was one of the conditions, if it was one of the conditions listed.
Okay. I didn't know if that was also included where if they committed a crime that involved illegal drugs.
I didn't get that far into the.
Okay, I was just curious.
It's really hard to figure out and dig into what minutia we want to go into. Yeah. This was more of a general, quick look.
My sense is that was probably most of those would be not charged as a new offense. The ones that were charged as a new offense would be up under new crimes.
Well, I think they're probably.
It would be double tapped a lot of times.
Yes.
Yep, sometimes it is. Yeah.
Yes.
Yeah.
Some of these are most everybody coming before the board is not coming just for one violation, one condition violated. They're coming for multiple violations, multiple conditions. And it was just, this was just the quickest, easiest way so I could give us an idea of what you're seeing.
Yeah,
because until we had, before this, you had no idea. You'd have a sense of what your repeats were, but you didn't have kind of the sense of what they were. The next slide.
I'm certainly not surprised by them.
No, that's exactly right.
The residents and the use of drugs being like that's huge. That's what I see
so-
almost all of them.
And so number 3, the reporting changes to residence or employment, that's also your reporting to your parole officer. I didn't put that caveat in. So those are a lot of our absconders. Because last year we were just shy of 100 arrest warrants issued. We haven't issued that many warrants for many, many years.
Wow.
We had
Mm.
a lot more last year.
Yikes.
So then the next one I found also interesting because when I did look at those new crimes, I wrote down generally what the new crime was that they might have been they were alleged with. This is more of what they were charged with. I didn't go into were they adjudicated on it. I just wanted you to get an idea of what some of these new crimes were that were coming before the board. And they go from one end of the gamut to the other in terms of severity. So I just wanted to give you guys an idea of kind of what some of these new crimes are. And I'm sure a lot of them are linked to like the substance use. They're linked to potentially the housing.
Mhm.
They're breaking into I believe the attempted murder was linked to housing because he got kicked out of his house. He got back into, and I think substance use. So it all was a swirling effect. So I just thought I would pass that along too, because I thought that was interesting. If you
Yeah.
guys saw my little, I don't even know where it went at this point. I had a little chart that I was handwriting and checking off as I was going through all, I think it was 179 violation hearings.
Hmm.
Because it's not easy to track this stuff. Or then extrapolate it. So then if we look at preliminary violation hearings, our probable cause custody status hearings, we had 86 that PC was not contested and 17 where PC was contested. I think in looking at my numbers, I don't know where my notes are. Hold on, let me see if I have them. I think that might be like an increase of 10 hearings since last year. So it's not a significant increase in preliminary violation hearings. We've been just trying to organize them better this year by having them every Friday instead of just when they're requested. And then we can look at rescission hearings, condition modification hearings. I can almost guarantee the rescission hearings, all but I think one were parole to detainer cases. And of the condition modification hearings, 12 of them were granted and 8 of them were denied. And I think some of those may have been towards the beginning of the year when we were looking at those, a lot of those condition 16s updates. And this is the end. So the couple things I want to note, some data that's not in here that normally is, and I haven't had a chance. I haven't looked at the early termination hearings. I'll get that for you for February. I will get you a full 2025. The other one is the victim testimony. We as an office have realized we did a poor job documenting victim testimony and victim letters last year. When I looked at the numbers, I was like, there's no way it was this low. So we did not, that's something we're going to need to QA and go through. So that's why that's not there. Because we are still getting active. We're still getting a lot of numbers. And so a lot of victims who are coming before either through the VSS writing letters or even coming to talk to you all. So that's just a general overview.
Thank you for doing that.
It's a lot of work.
Yeah.
Very nice.
Okay, moving on. Roundtable. Katie, anything new from you?
Not really new. I don't know about anyone else, but what I'm finding frustrating, and I'm hoping it's not just me, is when with this whole new push for risk designation, and once they get that, all it feels like all any sort of discharge planning stops. Like there's none. And so even if we want to possibly parole, there's been no work done for us to even be able to do that if we wanted to go against DOC. And to me, that's super frustrating, because a lot of times that leaves us having to take the offender's word for it on what they would do if we did parole them. Am I wrong? Like, am anybody else feeling this way too?
No, I feel that
I
way.
think that goes into what Tom's topic earlier was.
Mm-hmm.
It's,
Yeah.
it's very, the RSN designation when I was working was for the very rarely was it used.
So
And now everybody is, and you're right. Everything, even if there was planning in place, once that RSN gets on there, oh no, we have no plan. So yes, I'm very frustrated over that too.
And the offender's feeling the frustration with it too. You know, and saying like they're not helping me with any release. Like when we ask them about their release plan, what do they want to do? Like what's their plan if we were to parole them? They're like, well, I would have liked to have done this, but they're not working with me. It's just it almost feels like it's a way to get around us going against DOC in some way. But I don't know.
I think we've got a two-pronged question. I think there might be a two-pronged question because I'm taking notes for next month. I think there's I think we've got once a risk contained, what does that mean? What does release planning stop? And then I think you've got the second subsequent of they've been case staffed to be released. They submit a release plan. There's been a lot of release planning work. It's then sent to the executive committee, and then the executive committee says no. So I think we've got a couple different tracks that we need some explanation on and what casework is being happening.
Yeah, definitely, for sure. I just wanted to make sure I wasn't alone in seeing that.
No, and that's
Because when I
hopefully
look down through the parole summary and I look at it and then I all of a sudden see no release planning done. Like I feel like sometimes it means my hands are tied.
Yeah.
Well, obviously, there's been a pretty big pushback in the last year or so from the public's perspective. And in many cases, it's perspective and it's also perception. And in the past, that was never the case. And even from the legislature, that was never the case. The legislature was always pushing us in the other direction. And I think to some degree they are, but the administration clearly is not. And corrections has obviously changed direction quite a bit. And some of that is in response to some community involvement issues that have come up. And so they're being a lot more cautious. And, I think that's why the STMF process is even more important for us, because we still make our own decisions based on the evidence that we get presented to us and what we obtain in the interviews. And this is part of it, but it's not all of it.
Yeah. The other thing, I don't know if I already mentioned this, but and this, you know how a lot of times during the parole hearings we'll hear that part of their release planning might be to work with Better Life Partners. Better Life Partners is pulling out of Vermont as of February.
Really?
And it could be a situation where some of the potential parolees don't even know that. So they will no longer be serving Vermont as of the month of February.
That'll create a void. Sure.
Yeah.
I know a lot of people like to use them because it was all virtual. They didn't have to really engage in that. So any sort of MAT treatment coming out may need to include it's going to need to include something different than Better Life Partners.
Interesting. Thank you. All right, Pat?
Oh, no, I already said what I was gonna bring up, but I wanna thank the office staff. I mean, they do so much work behind the scenes that we don't even realize. So, thank you, girls. I appreciate you. I'm sure we all do.
Thank you.
I'll second that.
Without going into detail, I just think it's important that we talk at some point about safety planning for board members. And then with the new violation stuff, I'm chairing 2 days a month starting in February. So I haven't done a violation hearing yet, so just be patient and we'll get there. That's all I have.
Okay.
No, not at this point. I think probably in February, but like I say, I highly suspect PRO is doing a happy dance right now. It's gonna be a heck of a challenge for us.
It is. I agree. Tom?
No, I said my piece. I just got notified though the mayor of Rutland is resigning.
Really?
Other than that, yeah. Never heard of
When's
such a
his-
thing here.
When's his
That's-
term up?
Are you gonna run, Tom?
They've asked me, I said no.
No kidding.
Yeah. So.
All right.
Other than that, no, I think the staff have done a great job and I appreciate it. And we've been very, very busy at parole days, that's for sure.
Thanks. Angela?
No, I don't have anything. I'm good. Thank you.
Last up for me, I'm looking forward to getting together with Prisoners' Rights Office and MJ and having that discussion and then getting back to our folks to kind of see where we're going to be going with these violation hearings. And I think it'll be a little different. To me, it's going back to the process we used to use to some degree. But when it comes to the evidence, that could be a problem. We may be taking some stands and finding people in violation of things that we don't have confronting witnesses with, and I'm sure they're going to be appealed. But we'll just have to wait and see where it goes. So. Little concerned about that. MJ, did you have anything?
I think I've said most of
Yeah.
everything, I think, for the most part.
We did advocate too in the meeting with the legislature for an additional staff position in our office. So hopefully that will have some support and maybe get things going. So if you ever have any opportunities to talk with your legislators, that's an important piece for us going forward.
I'm going to be
I'm
staying
already
in February.
Yeah.
And I'm already starting to look at FY28 now that I know I've got to start thinking about FY28 now and not wait to see if anybody reaches out to me. Angela, when you said February, have you been scheduled for your confirmation hearing?
No, but I saw the schedule for hearings, but not my confirmation hearing. No, I haven't seen that yet anyways.
Oh, okay. When I heard February, I thought you were going to talk to the legislature.
No, I got a pickle thing, but we get to speak with our legislators about things that who we're experiencing. So I'll throw a phone out there.
Oh, okay.
Oh, I have to meet with them all the time with this new education change that's coming through the legislation, and because I'm on the school board here locally, so we're having all kinds of legislative meetings.
I'm sure. Yeah.
The whole Act 73, and it's just a big mess.
MJ gave us some SDMF forms to look at.
Yeah, I don't know how much you want to go into that. I did put up the data last night. I left the spreadsheet locked so I could get in it and make changes to it this morning. We had about 50 parole cases between I can share it. Give me a second. Between November and December, out of those 50, there were 10 that had discrepancies. So about a fifth of the cases had discrepancies. I don't know, just in the nature of time, it's 11:56. I don't know if you want to go through specific cases today, if we want to wait and save it for next meeting.
Yeah, I definitely want to go through it at some point because I think it's important to have
Yeah.
that discussion with the other board members, and so we can, try to the extent we can be on the same page. And
Yeah.
if we're looking at things differently, that's a way to have that resolved.
Right,
What do
absolutely.
others wish to do? Do you want to hold off on it, or do you want to do some today?
Can we look at it next month? Just, I also have a full-time job I have to get back to, and we've been
Yeah.
here for 3 hours, so just.
Okay.
I don't
I
think
don't know
we
if-
anticipated the staff meeting to go
No,
quite this long today,
we
and
didn't.
it's
We didn't.
because we're catching up for
Yeah.
Yeah,
Yeah.
that's
2
fine.
Yeah, well,
months.
let's hold off on that then, and we'll take another review on that. On the schedule, I think we're all set on that. Staff meeting, we're hoping to have in person.
And it has
At the
been
usual
changed.
place?
It is going to be in the Weeks building, and I've got the big conference room. It is not on the last Thursday of the month. It is on the last Monday of the month.
Yeah, I
23rd.
noticed that.
On the 23rd, because Dean is
Zipping
it-
home and zipping back.
Yes. So we're
I
accommodating
was
our
gonna
chair
turn in all
schedule.
my equipment.
I don't think you're gonna be turning it in,
I
Dean,
know,
at this
don't think
point.
so.
Nope.
We'll see. I don't
Yeah,
know.
we'll see.
I don't
Maybe
know
here
yet.
forever.
Good.
I don't think they can
Anything
work
else from
that
anybody?
fast.
No. Anything else from anybody? Okay, so Sam and Pat, I think after tomorrow's meeting, I may give both of you a call just to give you a heads up on what we may be looking at and on our violations. as far
Or
as
we
the
could
direction.
also schedule a schedule a meeting too, Dean,
Yeah,
if you wanted
yeah.
to.
Thank you.
Okay, we'll talk about that after our meeting tomorrow and figure out what's the best
Yeah.
way to go. Yeah,
Sounds good.
Perfect.
okay, thanks, everybody.
Thank
Bye,
you.
everybody.
Bye,
Oh, wait a
everyone.
minute. Whoa, I need a
Whoa.
motion to adjourn.
Motion to adjourn.
I have one
Second.
and a second. All in favor?
Hi.
Signify by saying aye. Thank you. We are adjourned.